warmly welcome you to this Doctor of Laws Public Defense for our candidates. I am Fide'le Ndayishimiye. Thank you for joining us as we examine and celebrate this important contribution to the legal scholarship. You're most welcome. My name is Laban Erwasa, the Registrar, School of Law, and also the Secretary to the examination panel for the candidate. Through you, Chair, I want to report to you that the doctor committee is present. The public is present. The examination committee is fully constituted. We have the quorum. Thank you very much. Over to you, Chair.
Thank you. Faculty members present, professors and staff of Makerere University, our panelists, members of staff from sister universities and students, invited guests, ladies and gentlemen, and of course, our doctoral candidate, our chief guest this morning. Good morning. Welcome to the School of Law. My name is Zahara Nampeo. I'm the Deputy Dean here at the school, and I bring you greetings from the Dean who is unable to join us today. And welcome to this doctoral defense. Your presence plays a crucial role in the public dissemination of knowledge generated through the research that we are going to be discussing this morning, which we hope is relevant not only for academic purposes, but also for policy, for industry, the legal sector, and generally the country's development agenda. But we are also here to witness a formal certification or otherwise, in brackets, of a new doctor of laws, and perhaps also for social and professional support. Ladies and gentlemen, this is the second doctoral defense this academic year at Makerere University. In the past, not very many lawyers have been doing PhDs, at least here at Makerere University School of Law, but this is changing of recent. Let us give a hand clap to our doctoral candidate who has taken this big step. So before we start, ladies and gentlemen, what is a public defense? At Makerere, we do our Doctor of Laws degree by research. In other units, they have taught PhDs. We are going to be discussing the doctoral thesis of our candidate in order to obtain a Doctor of Laws, an LLD. Therefore, our engagement this morning is for examination of a doctoral thesis. Our candidate has been examined both internally as well as externally, and he has passed. He had internal examiners and external examiners from both Makerere as well as outside, and that is why he's here with us this morning. What we are looking at in terms of the defense is the extent to which the candidate is familiar with their field, their chosen field of research, their ability to critically analyze the literature, their mastery of the research methods, the application of the research methods and the legal framework, and their research, their findings, and their conclusions and general contribution in the advancement of knowledge in this particular field. Ladies and gentlemen, today we are at the public defense of our candidate, who I am happy to introduce. May he stand. Mr. Ndayishimiye Fide'le. Fide'le, you're most welcome. and we wish you the best of luck. Before he starts, I'd also like to introduce his supervisors. Fide'le has been supervised by Dr. Benson Tusasire and Dr. Emmanuel Bagenda, who is on the way. We are also going to have a panel of examiners this morning, very carefully selected. And I will read their profiles at this point because once we get into the session, we shall just continue. This morning on our panel, we have Dr. Herman Butime. Dr. Butime holds a PhD in terrorism studies from the University of Wollongong in Australia. He's a lecturer in the Department of Political Science and Public Administration here at Makerere University. He also lectures at the Uganda Military Academy Kabamba, at the Senior Command and Staff College Kimaka, and the National Defense College of Uganda. Dr. Butime is co-author of Understanding the Lord's Resistance Army Insurgency. You're most welcome, Dr. Butime. Next to him is Dr. Sebastiano Rengabo, who is a political scientist, an international consultant with interest in fragility and resilience assessments, regionalism, international politics and security, political economy analysis, civil-military relations, and governance. He has undertaken several consultancy assignments with various international development agencies and local and regional institutions. His academic research, interests, and publications are evident in the areas of regionalism, international security, and civil-military relations. He's based at the Center for Basic Research in Kampala. Most welcome, Dr. Rengabo. We also have Dr. Dixon Kanakulia, who heads the department, who is head of department and senior lecturer in the Department of Philosophy at the College of Humanities and Social Sciences here at Makerere. He's the research coordinator at the Makerere Rotary Peace Center. He holds a PhD of Makerere University. He's a licentiate of Linköping University in Sweden. And he holds a Master's of Philosophy from Bergen University in Norway and a Bachelor's from Makerere University. He has extensive teaching and research experience on the East African community, human rights, and governance. Most welcome, Dr. Kanakulia. We also have our critical opponent, also known as a critical discussant, Dr. Livingstone Sewanyana. Dr. Sewanyana is a lawyer and human rights practitioner. He graduated with a Bachelor of Laws from Makerere University. He holds a Master of Laws in International Human Rights Law with distinction from the University of Essex in the United Kingdom and a PhD from the University of Cape Town. He's currently the Executive Director of the Foundation for Human Rights Initiative, a leading civic rights organization in Uganda. He has also served as a UN independent expert on promoting a democratic and equitable international order 2018 to 2024. Ladies and gentlemen, that is our distinguished panel, very carefully selected and very ably suited for today's engagement on Fide'le's topic. Fide'le will be telling us about the effectiveness of the East African Court of Justice in adjudicating human rights, civil and political cases. We are also live streaming this session, and there are also people online. And I know that there is family that is joining us in this defense, both online and here. I don't know, are there any family members here? Okay, all our family members for Fide'le are joining us online. Colleagues, you're most welcome, and I'd like us to start this session. We shall have about 60 minutes of engagement with the critical opponent, 45 to 60 minutes. And then there will be an engagement with the panelists, after which the panel will retreat to go and discuss the outcome of the public defense. Well, you have 30 minutes to present to us your work, and you're most welcome. Feel at home. You've been at the school, and this is your home. You're most welcome.
Thank you for the floor, dear Chair, members of the panel, distinguished guests, ladies and gentlemen, good morning. Today, I'm very happy to proceed to the presentation of the work entitled An Examination of the Effectiveness of the East African Court of Justice in the Adjudication of Civil and Political Rights Cases. The presentation will be articulated on 7 points. Number 1, introduction. 2, theoretical framework and literature. Number 3, the East African Court of Justice's legal framework and course human rights practices analysis. Number 4, we look at the silent features of the ESCG jurisprudence. Number 5, we talk about the implementation of the ESCG's CPR decisions. Number 6, we'll talk about lessons that we can learn from other regional courts. And lastly, we'll conclude and make recommendations. As introduction, human rights are becoming today a global issue, a concern beyond traditional states' competence. There are universal standards which are creating obligations upon stage. Their supernatural protection is no longer a debate. Today, there are integral parts of any regional economic integration. For this nature, we notice an interdependence between human rights and economic development. Today, regional economic communities are at forefront in realizing human rights, and their courts are today active adjudicators of human rights cases. Likewise, the East African Court of Justice has also evolved to deal with rule of law and human rights related cases. However, its ability to effectively adjudicate on human rights cases remain questionable. As problem statements concern, the rate of human rights violations in the EAC remains alarming due to a limited redress at national level, as reported by different studies. While human rights are part of the fundamental principles of the EAC, the legal framework does not have explicit provisions on the court's human rights jurisdiction. Therefore, the East African Court of Justice has not been able to effectively address the widespread violations of human rights and impunity documented in most of East African partner states. And due to the lack of express human rights jurisdiction, the legitimacy of the ESCG to entertain human rights matters has been a controversial aspect ever since its inception. And this concern is worsened by the manifest state's reluctancy and failure to adopt a protocol to operationalize human rights jurisdiction. And this structure and institutional challenges have been undermining the court's effectiveness in the protection of human rights, and thus raising a need for a thorough investigation. As general objective, this study sought to critically examine the effectiveness of the ESCG in the adjudication of civil and political rights matters within the East African community. This study sought to achieve 4 specific objectives. Number 1, to analyze the legal and the regulatory framework governing the ESCG from the historical perspective. Number 2, to investigate factors that affect effectiveness of the courts in protecting CPRs. Number 3, to make a comparative analysis between the ESCG and other more established regional courts. Lastly, it aimed to propose appropriate legal and institutional reforms to improve the ESCG's effectiveness in the adjudication of CPR. And 4 research questions were derived from the above research objectives. Why this study? This study was informed by the widespread of human rights violations and the poor human rights practices, followed by the blatant impunity under the umbrella of state sovereignty, especially regarding CPR violations. The researcher then set out to examine how ESCG can be activated as a viable forum to address this structure and institutional deficiency and practices. The study has used a specific research methodology. It integrated desk research methods and interviews to collect data. As far as documentary or desk research methods is concerned, it consisted in a critical and legal analysis of the relevant jurisprudence, documentary materials, and other legal scholarly writings. As research design is concerned, this study is qualitative approach, since it is used to collect and it collected and analyzed non-numerical data to understand concepts, opinions, and experience. It employed a case-specific model of assessing effectiveness of the codes by focusing on 4 salient dimensions. Number 1, the code structure. Number 2, volume of cases. Number 3, compliance rates. Number 4, finding and independence. In-depth interviews were conducted within a limited number of legal experts within the ESC. Interviews were conducted in Arusha at the headquarters of the courts and in sub-registries, respectively, in Bujumbura, Kigali, and Kampala. The purpose sampling techniques was used to select 20 respondents who were in position to offer relevant information or insights. At the end, data analysis, we used thematic analysis, which consisted in analyzing and identifying first and analyzing different patterns before we draw conclusion. This study is underpinned by a particular theoretical framework. It integrated theories underlying human rights, theories underlying international organization, as well as those explaining the effectiveness of the international courts. Theories on human rights, we have reviewed natural law, social contract, and liberalism theories just to understand the real nature of human rights. According to these 3 theories, human rights can be traced beyond the law. By opposition, we reviewed the legal positivism, which posits that human rights must be prescribed by the state through legislation. The study adopted natural and moralistic theory, which offers a real nature of human rights. The study argues that fundamental human rights, or specifically CPRs, existed prior to and independently from any legal order. The naturalistic and moralistic view of human rights has helped us to understand that in case a state fails to properly address human rights violation at national level, victims are entitled to call for supernatural protection. We reviewed theories on international organization or regional organization, constructivism, neorealism, and neoliberalism. Theories were reviewed to understand and explain the phenomena of proliferation of regional organization. To understand the functioning of the ESG, this study has applied constructivism theory, which interrogates the nexus between law, politics, and society, and its impact on the court itself. This constructivism theory helps us to fully explain the social, legal, and political context in which the ESG works, and that determines its performance. Lastly, we reviewed theories relating to explaining the effectiveness of the international courts. Case-specific effectiveness theory, embeddedness effectiveness theory, and erga omnes effectiveness theory, and non-development effectiveness theory, as developed by Helfer and Slaughter, were used. Besides, we used also cases and state compliance theory, which was developed by Posner and Yu. This study has adopted the two, case-specific effectiveness and case and state compliance theories, to assess the effectiveness of the ESG. These two theories enable us to understand both internal and external factors and dynamics affecting the ESG effectiveness in the adjudication of human rights matters. As far as literature is concerned, there are available studies which highlights internationalization of human rights through normative and institutional developments. Other studies focus on international adjudication, whereby human rights are becoming justiciable matters before international courts. However, international human rights enforcement mechanisms were proven to be deficient. That is the reason why there is an emergence of regional human rights system, mainly in Europe, in America, and in Africa, just to localize international human rights norms and standards, reflecting concerns of particular regions. Since this study is focused on Africa, we have reviewed literature on African human rights system with the focal points. This system emerged with the human rights mechanisms such as African Commission on Human and People's Rights and African Court on Human and People's Rights. However, studies highlight the deficiency of these mechanisms in protection of human rights due to two main reasons. There is jurisdictional limitations and other political challenges. As far as political challenges referring to African courts on human and people's rights, there is the lack of political will to ratify the protocol, and there are few declarations under Article 34, subsection 6. And this is worsened by increasing withdrawal of states' declaration. As of today, 5 states have withdrawn their declarations, which means that no states from EAC remains with a valid declaration, and no East African citizen can directly seize the African Court on Human and People's on people's rights. Consequences of this limitation is that denial of justice, there is a denial of justice of victims of human rights, which seems to be the order of the day. And due to this limitation, there has been a need to create African regional economic courts, which emerged to address the apparent flaws within the African human rights system. What is the relevance of the regional economic courts in the protection of human rights? This was a focus of this study. Some studies have emphasized on the appraisal of the role of African reg courts in fast-tracking regional integration, while others have focused on states' backlash towards reg courts practice in human rights. These studies denounce the political backlash and the crisis within reg courts in Africa. Other studies have focused on the common challenges relating to human rights litigation before the reg. They have raised, for example, the issues of the lack of clear human rights provisions within these courts and the lack of funding and the other issues relating to the implementations of their decisions. As a such gap, we have realized that there is a few investigation on why states backlash against their reg courts, and there are no studies appraising the impact of the deficiency noticed within the African human rights with respect to East African citizens. There are no studies on the role of reg courts in the enforcement of reg. And finally, there is a dearth of studies on the assessment of impacts of states' sovereignty on the effectiveness of the ESCG vis-a-vis protection of human rights. Before we delve into the matter of the analysis of the East African Court of Justice, this study has, first of all, analyzed the reason why we have come to human rights litigation at the ESCG. 3 or 4 main reasons are there. There are poor human rights practices within the ESC partner states. There are weaknesses of national courts, and there is the ESC legal framework which gives a room for supernatural protection. In addition, there is an increasing region of human rights activism. All these factors have justified the reason why we have the adjudication at this court. So the ESCG is described as an international court created under Article 9 of the ESC Treaty to ensure community law. It differs from the defunct East African Court of Appeal in terms of jurisdiction and composition. The ESCG human rights jurisdiction is subject to a conclusion of protocol. And this has been a bone of contention between the ESC partner states and human rights activism and the legal communities. As far as the ESC legal framework analysis is concerned, this indicates that there is no specific law applicable for the adjudication of human rights matters, no explicit human rights provision. And the courts, what does the court do? The court's reasoning of fundamental and operational principles, inter alia, human rights, democracy, and rule of law. There are legal and normative challenges. The jurisdictional framework of the court is found tremendously limited for the following reason. Number 1, there is the lack of clear human rights mandate. Number 2, there are procedural limitations and concurrent jurisdictional provisions as created by other parallel dispute resolution mechanisms as they are in different protocols. There are some contradictory provisions within the treaty, and above all, there is the lack of clear provision on supernatural nature of the ESG. Because of this limitation or challenges, they have been attempts to advocate for human rights mandates, but all these pressing calls from different stakeholders were doomed to failure due to harsh opposition of the East African partner states. However, the courts did not remain inactive. It crafted a genuine approach to adjudicate on human rights related cases. That brings us to the season of judicial activism at the ESCG. The adoption of judicial activism has enabled judges to creatively interpret general principles of the ESC. And this approach has been adopted for the first time in Katabazi case, where the court holds that it will not abdicate from exercising its jurisdiction of interpretation under Article 27, merely because the reference includes allegations of human rights. The relevance of this decision in Katabazi is that the court has demonstrated that human rights are integral parts of the fundamental principles of, as enunciated in Article 6 and 7 of the EAC Treaty. And human rights would thus entail the application of other principles such as rule of law, gender equality, social justice, equal opportunity, and democracy. This decision has had a very great impact as the case has opened the doors for human rights adjudication before the EACG. And this decision serves as a precedent in other subsequent human rights cases, such as in Katabazi, in Plexida Rugumba, where the court held that the provision of African human and people's rights were not merely decorative and of the treaty, but were meant to bind the partner states. In Imhochi case, the court has declared that principles governing the ESC are foundational, core, and indispensable to the success of integration agenda, and were intended to be strictly observed. Judicial activism now seems to be a living tool for human rights jurisprudence, as it has helped the courts to decide a great number of cases, as we can see there. The effect of judicial activism is that this approach has enabled that human rights related jurisdiction is somehow crafted, and human rights, especially CPR cases adjudication, is now possible before the courts. There is an increase of range of justiciable matters. There is also an increase of court usage, as more than 700 cases have been before the court, and more than decisions made by the court. Among them, 90% of cases touching on human rights. This has led us to trace the general features of the ESC jurisprudence. Normally, if we analyze the jurisprudence of the court, there is a predominance of cases touching on the human rights, rule of law and good governance and democracy, and with a particular focus on CPR. However, there is a very minimal role played in matters relating to trade and investment, which seems to be a paradoxal because the court is supposed to be economically driven. What are the salient features of the ESCG CPR jurisprudence? There are 5 elements we can underline. Number 1, the principle of primacy of community law over domestic law has been tested and upheld by the courts in different cases. Number two, the principle of precedence of the ESCG over national courts and the tribunal was upheld by the court in different cases, such as East African Civil Organization Forum versus the Attorney General of Burundi and two others, and in Karua case recently, where the court has declared the power of judicial review over national decisions, national court decisions. Number three, justiciability of fundamental principles of the community as enunciated in Article 6 and 7 of the ESC Treaty has been established in different human rights related cases. Number four, if you look at the jurisprudence of the courts, there is the use of legal diplomacy, whereby the courts carefully and indirectly determine human rights cases without directly confronting states. Number five, there is a reluctancy of granting damages in human rights cases. However, this is a common practice in cross-border and employment-related cases. If we look at the jurisprudence, we notice that there is an increase of jurisprudence of this court, and there are 7 factors which have contributed to this. Number one, there is the legal framework which have positive aspects because they include some human rights provision, either in the treaty or in protocols. Number two, there is the court's authority and independence and credibility, which were established from early sensitive matters. Number two, there is the practice of judicial activism as discussed earlier. Number four, the court has sought to network with lawyers and other partners. This has helped the court to establish its credibility. Number five, there is the role of interest groups which have supported the court and litigated earlier human rights cases before the courts. Number six, there is a deepening and widening of the community. As the community widens, there have been other matching cases flowing before the court. Lastly, there is the general development of human rights activism in the region. All these factors have contributed to the increase of the ESC jurisprudence. However, there are also political challenges. The traditional view of state sovereignty in the context of regional integration has been a greater hindrance in realizing human rights in the region. This resulting in political backlash sometimes, or resistance, or in some cases, the lack of political will to implement a number of decisions. Besides legal, political challenges, there are operational challenges of the court, which are summarized under 4 categories. Number one, financial constraints, which are determined by the lack of enough budget and the administrative and financial autonomy, with a negative impact on the dispensation of justice. Number two, there's the ad hoc operation of the courts, which did not change despite the increasing backlog of the courts. Number three, there are different legal systems and language which seem to be a barrier for some judges and advocates coming from French-speaking countries. Number four, there's a lack of public awareness about the ACG. Besides this, there are other emerging regional integration challenges relating to the frozen international relations between the states. For example, between Burundi and Rwanda, there is also political instability and security within some of the states. Here we note, for example, DRC, Somalia, and there are war in some of the states. There are also the closure of borders. I mean here between Burundi, Rwanda, between Rwanda, DRC, between DRC and Uganda. All of these challenges in the very near future can raise other cases flowing before the court. This study has moved on to analyze the implementation status of the court's decisions. We saw that the legal framework for enforcement itself is limited, as it is described under Article 38 and 44 of the EAC Treaty. What is the status of implementation and compliance? There are three tendencies which are revealed by our analysis, referring to 10 prominent civil political cases analyzed in chapter 4 of the thesis. We realize that there is first tendency is to be fully complied. 2 cases have been fully complied and 2 partially complied with, 4 not complied with, and generally the compliance rate was rated at 47%. There are also 7 determinants of state compliance, and these can move from internal factors to external factors. As far as internal is concerned, this deals with the nature of implementation mechanism, the nature of the court's decisions, and the nature of externally, there is the nature of political regime prevailing in the East African community, where states are illiberal democracy. But there are also others, for example, the involvement of legal communities and the civil society organization, the human rights litigation before the court. This was also another factor which can elicit the compliance. The study has moved to see the impact of the ESG human rights decisions. 4 types of impacts were identified. Number 1, these decisions have influence on national policies and actions as legal reforms were undertaken and changes of behavior recorded in some cases. Number 2, these decisions have regional effects, whereby we can see that some of them have influenced the filing of similar cases before the court. Number 3, democratizing effects of electoral processes. Here I mean the election of member states to the ELR. The members to the ELR has been democratized. Number 4, these decisions have contributed to the promotion and protection of human rights in the region. Implementation challenges are also there.
Fide'le,
the lack of detailed enforcement mechanism of the EFCG.
Fide'le, you have used up your time, but we give you another 10 minutes to wind up.
Thank you. I'm about to finish. Implementation challenges are there. We can notice 6. And the study has moved to make a comparative analysis with other regional courts, just to draw lessons to recommend to the ESCG. 9 lessons have been learned. Number 1, defining the ESCG as a supernatural institution. Number 2, to enhance embeddedness of the community law within the domestic law. Number 3, to involve the ELR in the nomination process of judges, as is the case in the European Union. 4, to set an ESC judicial council composed of judges selected by their tier. Number 5, to codify shared East African human rights standards in one document. Number 6, application of reference for preliminary rulings. Number 7, application of the principle of just satisfaction or compensation in human rights related litigation. Number 8, to recognize the post-judgment role of the courts, enable it to monitor its own decision. Number 9, to adopt a detailed and systemic enforcement mechanism for the court's decisions. As conclusions, albeit within a limited jurisdiction, the ESCG has, despite multiple challenges, played a key role in protecting human rights and furthering East African integration. However, the traditional view of the state sovereignty was found undermining the effectiveness of the ESCG in the adjudication of CPRs, thereby negatively affecting the court's role to properly advance regional integration and agenda. Contribution of this study is in twofold manner. It adds, theoretically, it adds knowledge to a continuous debates on human rights protection under the framework of the records. Number 2, it produces original insights into intricate dynamics surrounding the adjudication of CPR cases at the ESCG. Practically, this study offers valuable insights for policymakers, legal practitioners, and stakeholders, providing for legal and institutional reforms to enhance the rule of law and the protection of human rights in the region. The study has reformulated a recommendation to boost effectiveness of the ESCG. The East African policy organs should amend the ESC Treaty to recognize the court's human rights jurisdiction, to remove all other jurisdictional limitations within the treaty and protocol, and to redefine the court as a supranational institution. The amendments should also aim at developing a detailed legal framework for enforcement of the ESCG decisions. Finally, it should also address the daily operational challenges of the code by conferring it administrative and financial autonomy and permanent basis of operation. The EALA should adopt a model law on implementation of the court decision and other community law. This would assist in harmonizing the East African Court of Justice decision implementation processes within the ESCG. ESCG should amend its rules of procedures to include its role to monitor and follow up the implementation of its decisions. Practical reforms, individual states should move from limited ceding of sovereignty to the extensive ceding of sovereignty to the ESC and its organs. National courts should strengthen permanent dialogue, collaboration, and cooperation within the ESCG through the use of reference for preliminary rulings. And civil society organizations, human rights activists, and the legal community should create domestic compliance constituency in different East African partner states. This study is limited somehow and provides for areas for further studies. Since this study was limited to CPR cases, there is a need to interrogate the role of the ESCG in other categories of rights. Number 2, since this study was carried out from a legal perspective, there is also a need to carry out interdisciplinary studies to fully investigate the impact of the court's decisions on all spheres of life and all East African citizens. Finally, Further studies could also focus on the examination of the EAC decision on the impact the impact they may have on political regimes and the economic policies of the region. Before I end this presentation, I would like to thank the government of Uganda for having substantially funded this study, to thank also the supervisors whose effective mentorship and guidance was beneficial for me. Last, I want also to express my deepest gratitude to the ESCG management, East African Law Society, and European Union Institute for their cooperation and support during my field work. Thank you. That's the end of my presentation.
Thank you very much. I think we can give him another round of. Remember, we are here for professional support as well as social support. Thank you very much, Fide'le. It is said that the PhD student's motto is panic, hustle, deliver. PhD, panic, hustle, deliver. I think there has been little evidence of the panic. Maybe you overcame that at some point in the journey. The hustle, I think we have seen it from the content and the detail, and you have delivered. So congratulations. Thank you very much. And thank you too to your supervisors for this far that you have come. This juncture, we are going to have a discussion. Think you can, I don't know whether you remain standing or you take your seat, but let me now invite Dr. Livingstone Sewanyana as the critical discussant and opponent appointed by the Research and Graduate Training Committee of the School of Law to present your comments and engage the candidate on his thesis. Dr. Sewanyana, you have the floor.
Thank you, Chair and Deputy Dean, fellow panelists, the doctoral candidates, and our distinguished audience. First of all, I want to commend you for the progress you have made in this area at the School of Law, as well as the doctoral candidate for this milestone that you have achieved. Also, I want to thank you for the opportunity that you have given me to engage with the candidate. I know how much it takes for one to produce this type of work. I'll begin my engagement with Mr. Ndayishimiye. Okay. By looking at the character of the East African partner states, throughout the study, you have made a compelling case that the East African partner states are illiberal states. And in some cases, you have described them as multi-party autocracies. Agreed. You have also made reference to some states in Southern Africa as well as West Africa. And you have argued that the necessity for supranational protection is based on the character, abuse, and behavior of the states. Could you make a comparison of these states? If you look at the East African partner states, the West African partner states, and the Southern African partner states, how does their behavior and character compare to justify the establishment of these supranational protection mechanisms? Since they exist in West Africa, they exist in East Africa, and also exist in Southern Africa.
Thank you for the question on the comparison between the East African partner states and the Western states in terms of their character. This is a very important question. Yes. First of all, I will start with the similarities. In Western states, they are more democratic, and democracy, you know, it's known as a process. It has they are more experienced, and democracy or democratic values are strong there, and they have them as shared common values. Whereas in East African partner states, they are illiberal, which means that they have documents, they have their constitution, they organize elections formally, but in practice, it is a different issue. But since both sides, they are looking at regional integration, there are requirements relating to a regional integration. Among them, there must be the pooling of state sovereignty, whether you are in East African community or in Western ones. There is a need to pool state sovereignty if we really want that integration deepens. That's the reason why we compare the two, and we advocate for the supernatural nature of the ESCG, because this will have two positive aspects. Number one, comparing to what is happening in Europe, if a court is supernatural, it means its decisions takes precedence over national courts. And another advantage, if it is supernatural, it acts as a court of appeal, which can receive cases from national courts. So that's the reason why in European Union, they have advanced so much, because, for example, the Court of European, the European Court of Justice is able to receive cases from national courts and decide, and if it decides the decisions are fulfilled, they are enforced at the same level as if they are the ones issued by national courts. This has helped so much to integrate from economic to political level. And that's the reason why I recommend that, since in East African community, we aim at having a political federation, so states must also cede their sovereignty and allow the courts to decide matters relating to the integration the East African citizens sought for. That's how I can respond to.
Thank you very much. Moving on to the theoretical framework. You have looked at various theories.
Yes.
And you seem to subscribe to the universality theory.
Yes.
Of course, legal positivists, they believe that human rights are legal entitlements.
Yeah.
And the naturalists believe they are moral imperatives.
Yes.
In your view, then, how do you reconcile the neorealism theory, the neoliberal theory, and the universal theory?
Okay, new realism and new liberalism theory and universalism. Normally, let's start by differentiating by developing universalism. Universalism is a theory which posits that human rights are inherent, natural, and are the same for every human being, which means that there is no distinction and there must be common for all, which means that there is no human being without rights and vice versa. But if we look at neoliberalism, the neoliberalism posits that states must deregulate private sector. States, for example, must liberalize trade and reduce its control on the enjoyment of rights, which means that this neoliberalism somehow focuses on the free enjoyment of rights without limitations. While neorealism now, it comes just to contradict somehow the universalism, because in terms of regional arrangements, if you look at neorealism, the states are self-centered. They look at their gains, and somehow their gains might conflict with individual rights. That's the reason why my study disqualifies neorealism instead of or for the benefits of universalism. Yeah.
Would you then subscribe to the view that the East African partner states we are looking at here come from the viewpoint of legal positivists rather than naturalists, and therefore their behavior should be seen within that context?
You come again?
Would you therefore subscribe to the view that the East African partner states that we're examining here are legal positivists and not naturalists, and therefore their attendant behavior should not be actually shocking or questionable?
Yes. If you look at the East African partner states, we look at the political regimes, and we look at the way they function and the way they behave within the integration framework. It's as if they are strongly rely on legal positivism, because what they do seems to support their legal framework at national level, but not at regional level. Yeah.
Okay, moving forward, you have looked at rights, the rights discourse, and I entirely agree with you that some rights are derogable, others are non-derogable. And you went ahead to spell out those rights which are derogable and those which are non-derogable. However, I need clarification. When I read your study, you seem to argue that the right to life is non-derogable. Is it true? Does international law actually prescribe the right to life as non-derogable, or it allows permissible restrictions?
coming somehow broken. I didn't understand the complete idea. Could you please repeat again?
Should I repeat? Okay. When you look at the rights discourse, okay, some rights can be restricted. Other rights cannot be restricted.
Yes.
And you have spelled out rights that can be restricted and those that cannot be restricted.
Yes.
And I entirely agree with you. However, you have also noted that the right to life is non-derogable. And I'm seeking clarification. Is it true that international law does not actually allow permissible restrictions on the right to life?
Okay, thank you very much for the question. The right to life, first of all, I need to rely on natural theory, which says that everybody has the right to life. And when international law came in place, if you look at different human rights instruments, we can see that right to life is not derogable. So that is the point of international law, though some states still derogate to it. For example, those who still apply the sentence to the penalty, the death, while after judgment.
So you'd agree with me that the right to life is actually derogable. For example, in cases of the death penalty, it can be restricted by law.
According to my view, the right to life is not derogable. If we consider the perspective, the value, the dignity of any human being, it means that no one is allowed to take one's life. That's my position.
Okay, let's move on. Now, let's look at the East African Community Treaty. The East African partner states adopted the East African Community Treaty in 1999.
Yes.
And you recall that the East African community had collapsed earlier, and I agree with you.
Yes.
However, when they adopted the treaty, there was an understanding that they needed to revive the East African Court of Appeal.
Yes.
However, given the character of the states and the tradition, they chose not to confer a human rights mandate to the East African Court of Justice.
Yes.
Does that surprise you?
No, doesn't surprise me if I look at the nature of these states, which are by nature illiberal. And referring to constructivism theory, which I adopted, internally, if states lack values like human rights, rule of law, it will be exceptional to have their commitment to respect these values at regional level. However, they forget that making a regional integration, there are things like sovereignty, like any other power invested to the state, which must be losing. So if you look at the way states and civil society organization behave during treaty negotiation, we could see that states had their position while human rights, civil society have their own. States, since they are illiberal, they were illiberal, some of them transitional states. It was not, we can say that there was no possibility for them to move from what they actually are to what is required by the regional integration, which means that it takes time, maybe through international pressure and other diplomatic tactics. States will change little by little because it is a process.
Of course, I would imagine that the states relied on the fact that, one, they are party to the African Charter on Human and People's Rights. They also relied on the fact that Article 6D and Article 7, I think 7.2, already made references to issues of human rights. Why would they therefore have been in a hurry to incorporate a specific provision to provide for human rights mandate for the court?
Normally, yes, there is an incorporation of African Charter on Human and People's Rights provision in the East African Treaty. But this should not be a motive for states for not conferring to the courts the human foundation of civil and political rights are treated by states, which means that, yes, having this provision is not enough if we don't have a strong institution to enforce internally human rights.
When you look at the protocol that establishes the African Court on Human Rights, for anyone to access the court, unfortunately, and you rightly observe, that all the East African states have not made that declaration. And even Rwanda and Tanzania, that had actually made a declaration, have withdrawn. And yet, the East African Court of Justice, as provided in the treaty, has no human rights mandate. How has the court managed to navigate that situation? Correct. Do you see that as an advantage or a disadvantage to the court?
Normally, if we assess the effectiveness of any court, we need to look at the jurisdiction, the way the court is accessed by individuals. So far, the direct access to the EACJ is advantage for East African citizens because the community is people-centered. So we need to give rights to the East African citizens. They must participate in the process of integration. And one of the causes which led to the defunct of the first EAC was that private sector was not included, was not involved in the process. So to avoid this consequence, this far, what happened for the defunct EAC, we need really to give access to individuals to access the court.
But when you look at the volume of cases that it handles, and looking at the operational deficits it has, wouldn't you really agree that it needed to have that barrier? One, it is not fully functional, I mean, many times well-resourced, judges operate on a part-time basis, and yet it allows Evan and Dick and Harry to access it. Don't you think that in itself is a disadvantage?
I don't think so. Why? First of all, we come back to what is in the preamble. The integration should target individuals, should target people, which means that people must have the rights in this process, which means that if people are allowed to seize the court, I see the concern is to have a lot of cases in the court, but there is a way to do it. Either we increase human resources and also financial resources to solve this, because what matters most is the respect of rights rather than letting people dying or under impunity. It is better to improve, to do other strategies so that we focus on individuals. We could let all of them to see this, and the strategy is to improve the way of managing this through human resources management by increasing them. That's all.
Okay, we now look at the issue of human rights jurisdiction. You have ably discussed the necessity for a protocol to confer human rights jurisdiction to the court.
Yes.
You have also noted that IALA is positive about that development.
Yes.
What is the missing link? The Council of Ministers did dictate the necessity for that protocol to be established or adopted in the near future. The Parliament of East Africa is for the protocol. What do you think explains the inordinate delay?
Okay, that's a very important question. This study is legal but also has political aspects. We come back to the nature of things, the political regimes that we have in East African community. So, if we know that our states have very good constitutions, but practically that human rights are not enforced, and especially CPR. So the reason which explains this delay might be this nature, whereby we don't want states to be exposed. Because if a state is exposed to, if a state has violated human rights, and those human rights violation cases are in front of the court, this is somehow a state has been exposed itself. So that's the reason why they have to fight so that human rights remain with their national competencies, which is not logical if we look at the requirements of what we call a regional integration, which involve both economic integration and political integration. We must really, as states, change the behavior, because we are claiming a cake. The states are claiming a cake that they have already eaten, because adhering to a regional community means that you pull a certain amount of those remedies to the regional organization you have created yourself as a state.
Look at, you argued that part of the delay is actually attributed to the Anyanyong case. What happened in that case?
In Nyongo case, there was a case, this was a case on election of the members of EIA from the government of Kenya. So the government of Kenya, through parliament, has made what it called election, but which did not follow the provisions of Article 50 of the EAC Treaty, which provides how the process to follow while electing members to IALA. So when the case was brought to the court saw that the procedure followed were not in compliance with the provision of the treaty, especially Article 15. So the states of the government of Kenya was obliged to put in place other rules follow and which are in compliance with Article 50 of the EAC Treaty to elect their member.
When we look at the jurisprudence, both regional courts and international courts, there is a lot of acclaim given to the European Court of Human Rights.
Yes.
And largely because of its effectiveness,
Yes.
and its ability to enforce the decisions.
Yes.
When you look at the volume of cases that the East African Court of Justice has handled, what do you think is the added value of the court?
Could you repeat the question?
Okay. When we look at effectiveness,
That part I understood. The last question.
yes, added value. What do you think is the added value? When you look at the volume of cases that it has handled and its ability to enforce its decisions, what do you think is the added value of this court?
The values of this, the added values to this court.
In other words, if you will allow me, what does this court add? What is its significance and the difference between already existing mechanisms within East Africa? What is the plus or the bonus that it brings on board?
Yeah, there is a very great added value to this court. If you look at the volume of cases, as you said, it demonstrated that it has contributed somehow to the protection of human rights in some cases, because there are cases which have been complied with, and there are in some cases, some changes of behavior. For example, in Katagazi case, or Nyongo case, or in Burundi press law case, the states have changed they have made legal reforms, for example, in the case of Nyongo case and Burundi press law. So there is an added, of course. So we can say that the East African Court of Justice is playing a great role, though there are still challenges to be addressed.
Thank you very much. Let's look at the appointment process. When you look at the national courts, of course, they are appointed by the executive. Judges are appointed by the executive.
Yes.
When you look at the judges of the East African Court of Justice,
Yeah.
they are also appointed
Yes.
by an executive organ.
Yeah.
You have argued that there is need for an independent mechanism to appoint these judges. What sort of mechanism do you envisage?
This mechanism should be to establish a judicial council for the community, which is composed with judges with a high reputation and qualification. And those judges would be in charge of course, nominating the judges rather than leaving this task under the competence of the summits, the heads of the summits of heads of states. And this will increase the independence of the court, and also the credibility of the court. Because if you are nominated by the executive, there is a possibility, if we rely on what we call artificialism theory, to bring what you feel you have received from your home, you can be influenced. But if you have been nominated or appointed by this council, independence, total independence is ensured.
On a score of 1 to 10, help me to score the following. On a score of 1 to 10, 1 being the lowest, 10 being the highest, score the effectiveness of the European Court of Human Rights against the Inter-American Court of Human Rights, against the ECOWAS Court, and against the East African Court of Justice. Can I have your scores?
If we look at the comparative stat of these courts, we cannot have an exact score, but we can compare them regarding to the compliance rates of each. So in European courts, or in the European Court of Human Rights, the rate is higher than the rest of the regional courts we are referring to. But my study was not concerned with determining the exact rate, but it was concerned with the way it has been performed and the contribution, how far it has been.
And indeed, you have looked at the different courts. I think the question is simple. Tell us that is the European Court, I give 2 out of 10. Tell us that the ECOWAS, I give 6 for this one main reason. Give us the score for the 4 courts.
Okay, thank you very much. Though it is not what I...
Yes, it is not, but it is a question coming now.
Okay, thank you very much. If you look at the 4 regional courts, European Court of Human Rights can get 8 to 9%, up to 9 out of 10. And if you look at the Inter-American, it can get 7.5 out of 10, because there are still other challenges relating to it is the court itself which is involved in following up, and there is the lack of political ownership too in that case. And if you look at the ECOWAS court, there are still similar challenges with those faced by the ESCG. It can get 5 because now here we have clear rates. If you refer to the study done last year, in 2023, the rate of compliance was 47 for ECOWAS court. But recently, according to the report raised by the president of the court, there has been improvement. So the rate can go up to 5 out of 10. According to, if you refer to ESCG, we are still, the rate we said is 4.7 out of 10, because it's rated 47 per 100.
Thank you very much. Finally, supranational judicial protection seems to be a fast-growing phenomena across continents. If you look at the Americas, Europe, if conditions improved at the national level, would you still argue that they are a necessary evil?
We still argue that they are unnecessary.
If conditions improved at the national level,
Yeah.
would we still make a strong argument for a supranational judicial protection?
This should be automatic. If issues improved at national level, it means states have moved from illiberal democracy nature to liberal democracies. This will be automatic, because even though we don't even claim it, we know that when the ESCG has decided, the states will be ready to enforce its decisions, because human rights, rule of law, good governance, democracy are ensured internally.
But on the other hand, you have argued that countries increasingly are working towards integration, and integration comes with its own issues. Why would improvement at the national level undermine the necessity for supranational protection?
I'm not understanding you very well.
Okay.
Maybe the issue
Throughout your study, you have made a strong case for supranational protection. And supranational protection is largely dictated by the need for integration. And countries across continents are increasingly calling and working towards integration for economic purposes and other related advantages. If conditions improved at the national level, we are talking about human rights conditions, why would then supranational protection become unnecessary?
Supranational protection will remain necessary because as the states integrate, they are moving from one stage to another. There are what you call miles. For example, we take the stages of integration within ESC, moved from customer union, market, common markets, monetary union, and then to federation, which means as long as the states integrates, they will reach a level where the ESC organs, including the ESCG, when they make an act, when they decide, this will have direct effect internally. So I think if we talk about regional integration, supernatural cannot be excluded if we really include the idea of political federation. That's my position.
Thank you and congratulations.
Thank you very much, Fide'le, for that session. And let me take this opportunity to also thank our critical discussant for taking us through very neatly the thesis of Fide'le from the beginning up to the value addition. We'll now get into the interaction with the panelists. We have 3 panelists, but as chair, I would also like to sneak in a question which is related to something that the opponent raised with regard to the appointment of judges and considering how they are appointed in a political process. And you mentioned in your thesis, and you've also alluded to it here, the nature of our regimes, the hybrid authoritarian, nature of our regimes. From your case analysis, and you have done quite a bit of analysis of the cases in the court, what would be your comment about the judicial practice in the court? Is it largely judicial restraint because of the nature of the appointment, or has it been judicial activism? What is your judgment? And how have the judges applied creative interpretation?
Thank you very much for the...
Thank you very much. I'd like now to invite my fellow panelists to interact with the candidate, and I'll start with Dr. Herman Butimel on my far left. Dr. Herman, you have about 10 minutes.
Thank you, Chair. Monsieur Ndayishimiye, congratulations on reaching this milestone in your doctoral journey. My examination of your thesis focuses on the philosophical foundations of human rights. I intend to share my observations, and then you'll have an opportunity to comment on these observations later. My general observation is that you make a decent attempt at analyzing these foundations, though I think your analysis is not exhaustive. I will begin with your general observation on the rationale for human rights. And I commend you for citing 3 important bodies of thought: natural law theory, social contract theory, and liberalism. You are correct in pointing out that these 3 bodies of thought are premised on the assumption that human rights are beyond law. Okay, so you are correct in your interpretation. However, you demonstrate a lack of understanding of the relationship between liberalism on one hand and natural law and social contract theory on the other. You present liberalism as though it were separate from natural law and social contract theory, and yet, among others, natural law theory and social contract theory constitute the grand body of thought, liberalism. Number 2, I commend you for unpacking the position of natural law on the innateness or inherentness of human rights to human beings. Your interpretation of natural law in that regard is accurate. However, you're not sufficiently critical in identifying the tensions within natural law theory, because within this body of thought, you have competing strands. On one hand, you have the religio strand, the religio natural law theory strand, led by St. Thomas of Aquinas, that is premised on the assumption that the law of nature is not different from the law of God. But in diametric opposition to that position is the position held by Grotius, who attempts to divorce the innateness of human beings from the divine. So in your philosophical review, your work is not exhaustive. You make a decent attempt, but it's not exhaustive in terms of looking at the different dimensions to the discussion. I commend you for drawing on the works of the conservative scholar Edmund Burke. Edmund Burke brings to our attention the fact that human rights are subject to the organic evolution of the traditions and institutions of society. And I commend you for correctly pointing that out. But in your analysis, you consider that to be an attack on human rights. Seen differently, and again from a critical point of view, one could argue that Burke's positions don't amount to an attack on human rights, but rather illuminate the fact that human rights don't exist in isolation. Human rights don't exist in a vacuum. Rather, human rights are constrained by social structure. They are constrained by the historical evolution of societies, etc. So while I thank you for drawing on the important works of the conservative scholar Edmund Burke, I think you did not exhaust your discussion in terms of looking at the other side of the equation. Credit to you for also including in your philosophical review the works of Jeremy Bentham. Jeremy Bentham writes from a utilitarian position. And I agree with you. Bentham points out that before the emergence of the state, you don't have human rights. So human rights are a phenomenon that appears after the emergence of the state. Though, of course, again, you're not critical enough in explaining the conceptualization of the state. Are you talking about the liberalist conceptualization of a state? Are you talking about the Marxist conceptualization of a state? Because you have contestations among different bodies of thought on the genesis of the state. Okay, so you're not critical enough in getting into that zone of showing the leader from what perspective you're conceptualizing the state. But of course, you're right in pointing out that the utilitarian or the legal positivist understanding of human rights, the relationship between human rights and the state, is that the state appears before the emergence of the phenomenon of human rights. Though I thought that for purposes of the human rights discourse, one would have expected you to point out that very cardinal assumption that underpins the utilitarian approach to human rights, and that is society's drive to maximize the aggregate net happiness of the greatest number of individuals in society. That is what is central to the utilitarian school of thought as far as human rights are concerned. And it also has implications for the matter of minority rights. So these are some of the critical issues that are missing in your work. You also do well in bringing to the attention of the reader the seminal works of the philosopher Immanuel Kant. Immanuel Kant gives us this very important idea, the notion of a categorical imperative, and the idea that it's only human beings that have intrinsic value. Human beings don't have instrumental value. And again, I commend you for pointing that out. But if you had been more critical, you would have also understood that radical ecology contests that notion. From the perspective of radical ecology, and within radical ecology, you have different strands. Okay, one of the most prominent of which is ecocentrism. So the argument of radical ecologists is that every species that has sentience is the capacity to feel pleasure and pain, is entitled to rights. So they contest the idea that it's only human beings that are entitled to rights. Okay, so you have that contestation emerging from radical ecology. And if you had attempted to bring your work up to speed with our times, in the era of artificial intelligence, and going forward, we are likely to have a community of humanoid robots. So one would wonder, are we going to get to a point in time where these species also demand for rights? And how are we going to reconcile them to our understanding and rationale for having rights? So for now, I'll stop here, but I have a comprehensive number of comments that I am going to share with the registrar and the deputy dean. Otherwise, Monsieur Ndayishimiye, merci beaucoup, and félicitations. Okay, thank you.
Merci, Dr. Butime, since that is where we are going. May I also will need to display my skills. Parler français un peu. Thank you very much, Dr. Butime. Fide'le, I think these are largely comments, and you will receive a very comprehensive outline of comments that we'll deal with, but we can give you a minute or so to respond if you'd like to do that.
Yeah, thank you, Doctor, for the comments, very constructive comments. However, regarding the way I develop these philosophical foundations of human rights, in any research, we need to have a scope, some limitation. We need also to have specific objectives. What I needed here was to determine the real nature of human rights. So I consider that the three ones, natural law theory, social contract theory, and the liberalism theory, were enough for me to provide with me the nature, the essence of human rights. And I went to see the opponents, those supporting legal positivism, just to see that if you support that human rights do not exist where laws are not there, which means that there is a possibility to deny that we men or human beings have rights, because we have been dictatorial regimes. We have seen other institutions which do not respect morals, respect these natural values. So in this sense, if rights depends on what is determined by the society, it means when the society is out of what is dictated by natural law, it means people will lose rights in this sense. So that's the reason why we disqualify this one to return with the natural theory.
Okay. Thank you very much, Fide'le, but take these comments in good faith and see how to integrate them to improve your work. Dr. Rengabo, should we now turn to Swahili? Because I think...
Hebu niwarudishe hapa nyumbani. Asante sana ndugu yangu Felix Ndayishimiye. I thank you for the tremendous effort dedicated to examining the effectiveness of the East African Court of Justice in adjudicating civil and political rights. Thank you, Chair, for the opportunity, and I thank your doctoral committee for the dedication they have put in working with you up to this point. I request to make it more of an interaction because most of the foundational issues have been raised in the critical readers' observations and in my colleagues' submission. Let's go to your objective, the slide on your objectives. Down, there. Your general objective is to critically examine the effectiveness of that regional court, right? Do you think you met that objective?
Yeah, I have reached this objective because
You have satisfied that you have met that objective?
yes.
After meeting that objective, what problem have you solved?
First of all, we saw that effectiveness of this court can be assessed by looking at 3 dimensions. Number 1, the treaty efficacy, which creates the court.
Yes.
Number 2, the way the court is used by users. That's what we call the amount of cases. Has it been used? And number 3, we have to look at when the courts have decided, do its decisions, have they been implemented?
Very good.
So I solved this issue in demonstrating that we need to solve the issue of structural deficiency within the treaty. And also, we need states to move from limited sovereignty to a certain considerable amount of sovereignty. That will be a good way to move ahead towards political federation.
Thank you. Who determines the jurisdictional frameworks of the court?
Okay, these are, you mean
Simply put, can the court determine its own jurisdictional frameworks?
No.
If it does not determine its jurisdictional frameworks, is it appropriate to assess the effectiveness of that court on the instruments of operation that are not determined by the court itself, that are exogenous to the functioning of the court?
Normally, the court has a treaty as an instrument to be used. And this instrument was not set by the court.
Very good.
Yeah, it was set by the partner states and referring to theories which can explain the way we put in place a particular regime. We have to come back to the intention of states.
Very good.
We have to come back to the nature, the real nature of these states, which are illiberal. So if they have chosen to limit somewhere, the court's jurisdiction is that they had an intention, a hidden intention.
Thank you.
But through this study is there to show those policymakers that there is a need to change this initial position.
Very
due
good.
to the requirements of
Thank you.
integration.
The third element of your measurement of effectiveness is compliance with court decisions,
Yes.
especially by the partner states.
Yes.
Is that within the control of the court?
Is that?
Is compliance with court's decisions within the control of the court?
This will depend on the treaty. If the treaty, for example, involves the states to involve the court to monitor its decision, which is not the case
Mhm.
in East African Treaty.
Mhm.
It means the court, in this sense, would have something to play, some task to play in enforcing, in compelling states to comply with decisions.
Very good.
But since
Mm.
there is not this provision,
Mm.
we have to rely on the goodwill of states.
Very good. So we have seen that jurisdictional frameworks and compliance are exogenous to the effectiveness of the court because they are outside of the control of the court. And you draw them from your senior colleagues like Shan, who outline assessments of an effective international court, and they use these three as measures of effectiveness.
Yeah.
Do you think that those senior colleagues are correct in using these as measures of effectiveness of an international court when they are outside of the control of the court?
They can be, but they have to be combined, all of them.
They have to be combined.
Yes.
So where is the entry point of the East African Court of Justice on the basis of which we can measure its own effectiveness? Not the conditions that influence its effectiveness, because it appears that it is dependent.
Yeah.
Court will comply. Rules of the game will be in place. All these, the court depends on them, but does not control them. So when do we see the court itself effective? How do we measure effectiveness of the court itself, not the factors that determine its effectiveness that are exogenous to the court?
In this sense, we'll look at one factor only, which is the nature of the treaty. You see that the court has properly used what is provided by the treaty. But normally, effectiveness cannot be assessed on one fact.
Very good.
That's the reason why we need also to look at these external factors, dynamics, which, though they are out of the control of the court, they impact on the effectiveness of the court.
Thank you. Now, is it proper to conflate the factors that determine effectiveness of the international court with the actual effectiveness of an international court in a study at this level?
Could you explain to me what is the
Very
conflict?
good. Very good. You seem to indicate that we have three measures of the effectiveness of an international court: jurisdictional frameworks, compliance, and
The rate of
jurisprudence.
Yeah, jurisprudence.
But we have agreed that jurisdictional frameworks are not set by the court and compliance is not controlled by the court. And you are saying that you have been able to examine the effectiveness of the court. So now the question would be, is it proper to say that when there are exogenous factors or factors outside of the control of the court that determine its effectiveness, and exogenous factors that determine whether or not actors will comply with the decisions, when these are in place, we can effectively say that the court is effective?
Yeah, normally we look at these three factors
together.
That's the reason why studies are there. Even though these are external to the control of the court, these studies are there to call for policymakers to consider those factors, which obligatorily have their influence on the effectiveness of the courts.
Very good.
That's
Now,
the use of this study.
So from your assessment, is the East African Court of Justice effective, ineffective, partially effective, or some other definition?
Thank you very much.
Yes.
According to this study,
Mm.
the court is being effective,
Mm.
though there are still challenges to solve.
Very good.
Because the rate now is rated around 50. So it cannot be ineffective. It has done away in a very difficult, in an environment.
Moderate effective. Now, so therefore, what is your theoretical and empirical argument in this study?
Yeah, thank you very much. I argue that to improve on East African effectiveness, we need to address treaty regime issue and also to change behavior as far as states are concerned.
Finally,
from illiberal democracy nature to liberal democracy.
Finally, your findings seem to point to the fact that states are cagey about their sovereignty. And because of these sovereignty fears, they are not willing to cede some of their authority to the court. And you claim in one of the slides and in the literature that people have not tried to look at the ways in which sovereignty is affecting the operations of the East African community. Do you think that claim is based on exhaustive review of literature, or you think there are some writings that you may not have made?
Some writing?
Yeah.
Yeah, normally if we look at what is happening at the EACG, we really see that the main problem is coming from East African partner states as far as effectiveness of this court is concerned. So to address this issue, we need, as I said, states to change their behavior. But changing a behavior of a state is not something which can be done abruptly. It takes process, maybe through the findings of these studies, maybe also through the requirements of the regional integration. As far as they move ahead, there will be other challenges that they really need to solve before they go far.
Finally, from a theoretical, methodological, and empirical point of view, you show us the main inferences that can be drawn from your study to learn more broadly about international human rights adjudication.
Could you say again?
I am asking about inferences. What more can we learn about the world from your studies' theoretical, methodological, and empirical components?
Thank you. You can learn from this study that states' sovereignty, the enjoyment of state sovereignty in the context of regional integration can be a barrier to effective regional integration. So we need to look at the political regimes to see whether there is embeddedness of the values which are commonly agreed in the treaty. We need to ensure that they are internally embedded in their national law. And also, we need to look at the national courts, the power they are given by the executive, by the law, because most of the time they lack judicial independence. In this sense, if they lack judicial independence, there is impunity in some cases. And that is the reason why, in this case, some and very important number of cases have arrived to the EACG. Yeah.
Thank you, Chair. Thank you, Ndayishimiye. Congratulations.
Okay. Thank you very much. So the answer to the effectiveness of the court is more of a political. Well, we'll leave it to, but now let me invite Dr. Kanakuli. I don't know what you're going to speak. French has been spoken and Swahili. You know some Burundian?
It's come out already. I will try to bind his wounds, I think, so that he doesn't get a stroke on the podium. So I'm going to be, I can't do rapid fire like my previous speaker, so I can just, since I'm the last, I'm going to cut my questions short. But I wanted to start with something very simple, which I tried to look in your work and I didn't see. There are some axiomatic principles you have to start with at the PhD level, basic things. What did you understand effectiveness to mean? You don't have to answer that because it has already been raised. But I think when you go back to do correction to your work, there's a segment that you should dedicate to answer the question, what is effectiveness? Because it is pivotal to your work. You picked ideas from different scholars, but your voice didn't come out, what you understood effectiveness to mean, and therefore the measurement became a problem. And that's why I was happy when the critical reader asked you how you measure other courts. We don't hear even that in your abstract. What was your final verdict about the effectiveness of the ESCJ? We didn't get it at all. So you need to, first of all, clarify. Just to give you, I tried in my comments, you'll find it there, but for now, I would say when I read through your work, I could see two types of effectiveness, which I don't think you can do it now, but you can think about it. There's legal effectiveness, the performance of a law or an act. Then there's judicial effectiveness, performance of a court. So if you clarify those two ideas, maybe the confusion will go away. And I think most of the things have been rotating around that. Then I also want, you don't have to answer that. I'm just going to make comments. I don't want to fire you, the rapid fire that you have been getting. The Article 23, which establishes the court, let me quote it directly, verbatim. The court shall be a judicial body which shall ensure the adherence to law in the interpretation and application of and compliance with this treaty. So that article already gives you 3 performance measures, which I thought you would have examined in line with the treaty. So time cannot allow us to get details here, but think about that, because you must have, you tended to have gone out of the treaty and then you borrowed in a lot of things that cause a lot of challenges. Then I go back to what Dr. Witim was raising theoretically or philosophically. He raised all the things that I had mentioned. You find them in a report, but I want to highlight this particular thing. This is a challenge that many legal scholars land into, especially those who are critics of legal positivism. You equate legal positivism to either logical positivism or sociological positivism, which becomes a problem for you because that is a formalistic approach. If the letter is not followed, adhere to the letter, then the law has not catered for, maybe in case of human rights, I catered for these rights. But if you follow the debate with H.L. Hart and other scholars, legal positivism is wider. It gives sanctioning power. I know you dismissed it. in my comments, you find I examined that issue mentioned in your work a lot. You simply dismiss that it doesn't hold any water in your work. And you have kept repeating that you are a naturalist, but Dr. Witim said that even social contract could have been a very good theoretical framework. Legal positivism has played a key role in promoting human rights around the world, from the Declaration down to all other instruments. So if you dismiss it outrightly, moreover, to me, your dismissal was not grounded enough in theoretical analysis. Legal policy would have helped you to argue for the case for the regional court, because it is the regional court. I don't know, I don't want to use the very terrible words, but they removed its teeth. This sanctioning power is not there, which is one of the things that legal policy gives a particular court or an area, a body that is have jurisdictional powers. So you dismissed it, but your grounds for dismissing it, to me, were not good enough. And I think that's because you are now arguing from sentimentalism rather than from the actual practice of law. Without the law written down, the court is powerless. And that's what he was raised. I think it was Dr. Timo who was raised that the summit or the treaty did not grant the court the oversight over human rights. And that's what you're trying to measure it against. In its establishment, the human rights were not given to it. It doesn't have powers over, you get it. So it is a challenge which you should have gone in detail. Most of the details are in the larger report, but I want to end with this on a lighter note. You cite the case of Best J and now versus Uganda. You remember that case? And I thought that, for me, when I was reading, that's one of the cases I was waiting to read. Such a huge volume, and that case would have taken space for you to analyze and discuss. I thought it was going to be informing. But instead, you put your scanty discussion in the footnotes. Right as we speak, rather, Best J is in incarceration. And he was, in quotes, abducted in Nairobi. But if you notice, this time he didn't go to the ESCJ. He is battling it out here in what? In Uganda. And that is an area for you which would have been very rich discussion for you. Why is he doing that? Why are the lawyers advising him to do it from the state or the national level? What is happening to the regional court? It would have been a very interesting discussion. You seem to have scattered around that discussion and simply put in a footnote that Best J was abducted and blah, and you left it there. Yet it is something that is current during your time of study, which I thought would have given you more mileage in discussing the limits and the performance of the court. And lastly, the trust. There's a doctrine of public trust, which is very is pivotal in legal studies, isn't it? This is something that I thought was going to be a very central part of your discussion. Courts or all these bodies, if they don't have public trust, they don't perform. They don't function. But it appears, perhaps in a contrary way, the public trusts the East African Court. The level of cases you cited, over 300, which you said you studied. I have question marks on that in the methodology part, but for now, we're not going to go there. How you did all those cases, that's another story. But that's the average you said was around 34 per year. That is a high level of trust. And this doctrine would have come in for you to raise as one of the performance indicators of that court. But you leave it there, it doesn't go in detail. Why do people have a lot of trust and the politicians don't trust? Or the key decision makers at the national level? Why people keep going there? That's a question that you should have given mileage to discuss the performance of that court. And that doctrine of public trust is a very fundamental doctrine in legal studies. But in all your work, it doesn't appear anywhere. Apart from saying that people take their courts, I think Rwanda has the highest, 90-something cases that they have taken to the ESCJ. But that is something that you should have examined as a legal scholar at PhD level, and you just brush or didn't even look at it. I don't think that would have been that would really be a satisfactory job. So if you're going to go back, you find more comments in my report. That doctrine of public trust in law is very, very central and pivotal. So if you don't discuss it anywhere in the work, I find it a bit lacking in a way. So I'm not asking you questions. I was just trying to give like some advice or a way to improve, area to improve. Thank you very much.
Thank you very much, Dr. Kanakulia, for the comments. Definitely they will enrich the work of the candidate. His lead supervisor is here and they'll be able to work on the comments. At this juncture now, it's time for engagement with the audience, members of the public. Part of the reason why you're invited is to, see the contribution to knowledge, to policy of the work, the research that has been undertaken. So this is the opportunity for you to raise any questions or comments. We have a microphone moving around. If there are any questions, please raise your hand. Tell us your name and where you're from and raise your question in a minute or so. Any questions? We also invited the Ministry of East African Affairs, who are hoping they are here to listen to some of these policy considerations. Colleagues, any questions? Yes, there's a question from Dr. Kabumba, and then Registrar, you could check online and see if there are any questions that we can read out. Dr. Kabumba? Question or comment?
A question. Thank you very much, Chair. I didn't intend to ask the candidate a question, but since the members of the general public seem shy, I might as well prompt them by my own question. Fide'le, mine is just about the kind of civil and political rights that you considered and the scope and breadth of those rights. Did you consider all of them or some of them? And if you excluded some, could you justify and explain to us why you excluded some of them? Thank you very much.
Thank you for the question. When I was selecting cases to analyze in chapter 4, I could not deal with all cases. We selected 10 prominent civil and political rights cases, which had had a great impact on human rights discourse in the region. So I didn't consider others because I judged that the 10 were enough to give enough information to understand how the court is performing in human rights related cases, especially those relating to CPR.
Yes, thank you. And which ones? Dr. Businja, if I got your question rightly, which civil political rights cases did you consider?
Okay.
And what observations did you make with regard to the judgments in those civil political rights? Were they soft issues? Were they declaratory judgments?
Okay, thank you.
So give us an overview of the kind of civil political rights issues that are handled in the court. I hope I'm representing you well.
Thank you very much. As far as CPR cases handled by the ESCG, the most important which comes at the forefront are press and media cases. So very important, either if you consider those coming from Burundi and those coming from Tanzania. Tanzania, for example, there are two. There's what we call Tanzania Media Council case and Mseto case. In Burundi, we have what we call Burundi Press Law, which has determined around 2014. And there are many other cases, but the behavior of the court in these cases was that they considered that human rights are related to press and media freedom. The court considered that we cannot have a democratic society without respecting the freedom to media, freedom of expression.
Okay, so
Another-
that is one issue. That's media rights.
The
Media rights,
Oh.
freedom of expression.
For example, the issue was to oblige journalists
Yes.
to disclose the source of information.
yes. Okay.
Or in another case,
No. Another category of right.
another category of rights was freedom
Of movement.
Yes.
Yes.
We have two cases, Rufikiri cases from Burundi, who was barred from moving from Burundi to outside. In another case, Mohochi case, who was coming from Kenya, arrested at international airport in Entebbe. And the court decided that the states cannot use their own laws disregarding what is provided by the ESC treaty. Another type of cases relates to the extrajudicial killings and the torture. We have one case in Kenya. We call it in independent medical legal unit case, where we have around 3,000 people who were tortured by the officials of the government. The case reached the court, and at the first instance division, the court was received and determined, but when at the appellate division, it was dismissed. And that's the only case where we see that the court has applied judicial restraint.
Thank you very much. By long association with someone, I can see that his supervisor is itching to ask like 7 questions in his own right as an individual, but I shall not let him. Yes, colleagues, if there are no other questions, I think we have had a good interaction. We have a good idea about this thesis. There is evidence about diligent attention to the area of study. There are no questions from our participants online, who I would like to thank for being with us this morning. It is 10 to noon. Kindly allow the panel at this point to deliberate on the outcome of the public defense and revert back on the result. But before we do that, let us just give another, hand clap to Fide'le. Because sometimes, PhD, when you are with your legal advisors, your supervisors, now even the panelists in the public defense, the session becomes very emotional. You feel like adversaries, but this is by no means meant to be that way. It is collegial and intellectual discourse. And of course, there might have been some emotional marathons happening here and there. But this is all for purposes of building the jurisprudence and the discussion around the topic. So thank you very much, Fide'le. Please allow the panel to go and deliberate, and we shall be back in about 20 minutes or so. Thank you very much, and please stay around. There will be some soft music playing. Fide'le, you can take 2 bottles of water in the meantime. Yes, good afternoon. Thank you for waiting. Sometimes we wait for black smoke or white smoke, or, we wait and wait and wait. We have many examples where we wait. Thank you very much for staying behind. The panel has deliberated, and the outcome, congratulations, Fide'le. Fide'le Ndayishimiye has passed the public defense. He has illustrated, and the panel is satisfied that he had a good grasp of the law. His findings and methodology could be explained. They have also shared comments, both orally here as well as written, that he will work through with his supervisor. Fide'le, you have about 2 weeks. We have a deadline as a university to submit our graduation list for PhD by the 31st of December. So if you want to be on that graduation list, the panel has passed you subject to those corrections. But congratulations. They say that a PhD is 1% inspiration, 99% panic. You will have a brilliant idea, but the rest of the journey, you're moving between your supervisor, legal advisor, having a love-hate relationship, repeat this chapter and whatever. Thank you for the diligent effort that you have put in to get this far. It is not easy. And as the School of Law, we congratulate you for being the 2nd doctoral candidate for this academic year. And I don't know if there are any family members online. We'd like to thank you as a school for supporting Fide'le. Fide'le was a regional student. No wonder he worked on a regional issue. He was from Burundi, so he would come and he would say, Doctor, I'm running out of funds for accommodation. I need to go back. But Fide'le, thank you for the resilience, and we are proud. We congratulate you once again. I also see here the representative from the Research and Innovations Fund of Makerere University, Miss Winnie Chamlabi. At some point, Fide'le really needed a push. He needed a financial push, and the government of Uganda came through. Winnie and the team at RIF, we appreciate for making this possible. Dr. Benson Sasri, just stand up, please. Stand up. This is your moment. Yes, congratulations. Dr. Team Patricia, chairperson of the doctoral committee. I don't know, Dr. Josephine Ndagire, they're not here, but we thank the doctoral committee that led him through his journey. We thank the supervisors, Dr. Emmanuel Bagenda in absentia, and also we thank the panelists once again. Fide'le, do you want to take 3 minutes to say something? And it is okay to cry. I think that caller worked wonders. Fide'le, you're free to say something if you'd like. You can put on your microphone.
Thank you for your attendance. But particularly, I want to thank again the government of Uganda, which substantially funded this work via MACRIF. And I'm grateful also to the whole staff of School of Law. They were cooperative and very inspirational for me. I thank you for the administration or the management of the School of Law, which did everything for me to do an internship in Europe, where I got enough experience on the way regional court works. Thank you very much. May God bless you.
Okay. Thank you very much. Congratulations once again, and we look forward to seeing you on the 27th or the 25th or the 26th of Feb in that gown. Colleagues, before we adjourn this session, we have another doctoral defense this afternoon. We'll be talking about taxation and the Uganda Revenue Authority. Please come and listen to the knowledge generation and innovativeness at the School of Law. Thank you very much for attending, and thank you again to our panel. Can we have a photo as the panel and the candidate? Please put some nice music, DJ.